Hearing in appeal of Centrica overseas holding efficiency against principal use directly the customers.
Mr. Rivet.
My lords and ladies, I appear on behalf of the appellant, Centrica Overseas Holding Limited, together with my learned friend, Mr. McGee, on behalf of His Majesty's Revenue and Customs, Mr. Hewitt, King's Counsel, appears with Mr. Henderson and Miss Belgrane.
Thank you. So I'm just bringing up the documents.
My lord, what I was proposing to do was to address you by reference to principally the core bundle, if that was of assistance, but I've also got references for the, sorry, not the core bundle, by the main bundle. I've also got references to the key documents if you wanted to.
Well, I think, unless my colleagues say otherwise, if you give us the electronic page number from the core bundle, that will suffice. Great, thank you.
So, my lords, my ladies, what I'm proposing to do is to focus. There are three issues, I submit, three core issues that I need to address over the course of my allocated time. The first is a question as to the facts, and I'll come to that in a moment. The second is the what I may call the narrow construction, which is our primary case as to the scope of section 1219. And the third is to deal with what we might call the trading case authorities, as to capital exclusion. What I'm proposing to do when I turn to the core of my submissions is to start with the facts, perhaps unusually, because in my submission, where these proceedings have gone wrong is that there has been a departure from the findings of facts that were made by the first-tier tribunal. And so if I might start by making three observations before I invite the court to look at the findings that were made by the FTT. The first is that the crux of the Court of Appeal's decision in this matter is that money which is expended in order to achieve the disposal of assets is properly to be regarded as capital expenditure for the purposes of the provisions here in question, and that in these circumstances money was expended in order to achieve the disposal of assets, albeit one that never happened, and was therefore capital. Our fundamental point on this is that on the findings of fact that were made by the FTT, this is not what the money was spent on. And that whether the meaning of capital expenditure in the context of section 1219 subsection 3 is given an autonomous meaning in the context of the expenses of management code, or whether you identify it by reference to existing principles, such as they are, which may be drawn from the case law of the courts in the context of evaluating whether capital, whether a given sum is capital in the context of trading cases. In either event, on the findings of fact that were made by the FTT in these proceedings, the expenditure was not capital expenditure and was not capable of being characterized as such. In these circumstances, we submit that the FTT was entitled to find that the expenditure here in question was incurred to procure advice which was to be used to enable coal to make decisions about its investment in Oxio, and was part of the ongoing management expenses of coal, as it enabled the company to make decisions about how it might realize value from its investments in Oxio. And that being the case, there is nothing within the provisions of section 12193A, as properly construed, to prevent the expenditure from being deductible. The second point that I will make good when I come to develop my submissions as to the construction of the provisions of section 12193A is that once one has understood the high authorities that come to the consideration and evaluation of what constitutes an expense of management in the first place, in the context of the businesses here in question, it should not be a surprising conclusion the category of expenditure which is excluded by section 12193A, as properly understood, may be relatively small. And the third point to me is that by definition, the category of companies with which we are dealing here consist either wholly or in part of businesses which carry out investment business. By definition, therefore, particularly on the facts of this case as it vividly illustrates, at some level of abstraction, all expenditure this company incurs is connected to a capital asset and an actual or potential transaction. It is a radically different type of business to a trading company. I will submit that the findings of facts that were made by the FDT in these circumstances is such as to make plain the type of expenditure here in question was the daily bread of the company here in question. And that if the Court of Appeal's decision were to stand, the effect of its reasoning, given the point at which it identifies the expenditure as being capital expenditure, would be to decamp the relief of its operation. I have set out in quite a lot of detail, I have 2 hours this morning. What I'm not proposing to do with your leave is to take you in great detail through the submissions that are recorded in our written case. What I would like to do with your leave, clearly to address your questions, but also to focus upon, as I said, 3 key areas. And the first point that I would like to start with, if I may, is the actual findings that were made by the FDT. Because a lot with respect to the things that went wrong in the Court of Appeal and the reasoning and its approach to the application of the case laws here in question arises from a misunderstanding of the facts and what was open to the Court of Appeal to find. We've set out in detail in our written case, and the Court will be familiar with the way in which this particular issue was decided in the various tribunals below. And I don't propose at this stage to revisit it, although I will come back to some comments from the upper tribunal and the first tier in a moment when I come to look at the facts. So if we might start, please, by looking at the findings of fact that were made by the tribunal regarding the nature of the business. I'm going to group my submissions in relation to the findings of fact into 4 separate categories, which will, I submit, correspond to the principles, such as they can be identified, that one draws from the case law, which I'll come on to identify in due course. The first category of facts that I will invite the Court to consider is the findings that were made regarding the nature of Coles' business and how it was operated. And we will see from some of the authorities that the important point is that the departure point for the consideration of whether a given sum constitutes revenue or capital in the context of a given business is always a consideration of the particular business there in question. The second category of facts will be to look at the findings that were made in relation to the context in which the expenditure here in question was incurred, to the wider context in which this was incurred. The third category will be a point that I will submit is critical to the determination of this case, which is on what was the expenditure incurred. And the fourth category of facts and findings that were made by the FDT address the question as to what advantage to the company was secured by the expenditure incurred. If I could invite the Court, please, to turn up the FDT decision, and it can be found on page 309 of the electronic bundle. I mean no disrespect to the first tier tribunal when I say that there is an element of navigation that's required, because some of the findings of fact that relate to multiple issues are found at different parts of its reasoning. But this first category of findings of fact are conveniently located in one place. So there are detailed findings of fact that are made in the first instance about the nature of coal's business, and these start on page 312, paragraph 13. Yeah. Coal was an investment holding company. Paragraph 14, Centrica Group is well known as a major participant in the energy market. It operates in the UK, North America and elsewhere. And its activities include energy supply, gas and oil exploration, development and production, and the operation of power stations. It's the biggest supplier of energy to the UK domestic market. Paragraph 15, coal was and is a substantial intermediate holding company, holding the group's investments outside the USA. As at the 31st of December 2009, the company's book value was 1.3 billion odd. Its investments included shares in and loans to companies in the UK, Spain, Canada, Norway, India, Germany, and other European countries. I'll come back to
Those are intra-group loans, are they?
My lady, yes. And there were also, there's a finding of fact that those loans, so far as they're concerned here in question, were loans that were made by way of investment. They were interest-bearing. In fact, I can make that good because there are a number of sets of financial statements, but one of the financial statements you can find at page 698 of the bundle. And these are the financial statements for 2009. If one looks in particular at page 701, you can see a list of the types of shareholding that are there in question. For present purposes, you might want to look at the paragraph on page 698, which records capital contributions being made to Oxio BV, which is one of the companies that's here in question.
Where do we see this?
My Lord, I'm afraid they're not numbered, the paragraphs, but on the 23rd of March 2009, there's a list of findings that are made on this, which I'll take you to in the FTT decision, my Lord. This is just to illustrate the scale of the activities that were carried out by this holding company, to set in context the nature of the expenditure in due course. If we might turn back, please, to the FTT decision. Like here's an explanation in answer, in fact, to my lady's question in paragraph 18 regarding the provision of financial support. There was a great deal of evidence that was before the tribunal, evidence given from a number of witnesses and in bundles about the activities of the company. This is a distillation of the findings that were made in light of that. And in paragraph 16 onwards, we see an account of Oxio, to which the expenditure on the services here in question related. Coal provided financial support to Oxio throughout the period from 2005 to 11, provided debt financing for an intergroup revolving loan facility. As at the 31st of December, the balance outstanding was 91 million euros. Then there was an equity investment that was also made. There were also, in the bundle before you, but I don't propose to take you up to it, a number of board minutes that explain the decision-making that was made regarding the investment that was made into the Oxio subsidiaries and the provision of loan finance and capital injections that were then made. And the short point I make at this stage in relation to it is to observe the sheer scale of the activities of the investment business that were carried on by coal, including capital contributions, acquisitions, subscriptions for shares, disposals, debt financing, and the range of the holdings that it held at the time of the events here in question. The next category of findings in this bracket related to the nature of its business is to explain a little bit about how Centrica was organised, or coal was organised, and how it conducted this business. And in particular, I'd ask the court, please, to turn to paragraph 35 and 36 of the FTT, which records some evidence that was given to the tribunal regarding decision-making in the Centrica Group. And in particular, in paragraph 36, strategic decisions for the group were made by Centrica. Centrica is the PLC, not coal. This was facilitated by various central teams who would provide advice and support for the group in areas such as legal, tax, accountancy, regulatory matters, finance and mergers and acquisitions. Individual companies within the group did not have their own teams dealing with these matters, but would be provided with support by the central group-wide teams. Most of the employees were employed by a small number of groups, and many of the subsidiaries, such as coal, had no employees of their own. If we turn on a little to paragraph 53, we see some evidence that was given regarding the practical operation of the decisions that were made by these companies, and evidence from Mr. McCourt regarding the procurement of services. Mr. McCourt stated that Centrica would routinely procure services for entities elsewhere in the group, with the cost being borne by the ultimate consumer of those services, i.e. the entity that benefited from them. And the same point is made by Ms. Rad.
By an intra-group transfer.
My lady, yes. I think what this, in fairness, what this particular points, my lady will have in mind that one of the issues that was before the FTT and then went up to the upper tribunal was the question of, in circumstances where the expenditure was borne by one company and decisions were made by others, how did this operate from a corporate plumbing point of view, as it were? And I think that some of these findings are directed to those questions as to who was doing what and when. Nevertheless, in this context, I submit that it is relevant because I'm going to submit in due course that the types of services here in question, which were the subject of the expenditure, are precisely the types of services that it was incurring all the time. This is what Centrica does and coal does. And that's relevant to the evaluation of the recurrency principle that we see in some of the cases when it comes to capital and income. And if one turned on a little bit further to paragraph 423.
Paragraph what, sorry?
423, in other words, it's page 394. Mr. McCourt's evidence indicated that much of the sort of advisory work which is an issue in the present case could be, and often was, provided by group functions, and that Centrica would buy an assistance of advisors like Deutsche Bank for various reasons, but including their ability to do the heavy lifting where there was insufficient house capacity. There is no suggestion that the cost of the in-house teams involved in the Oxio transactions should be disallowed. So that is by way of just an introduction to the various findings that were made about the activities of coal and the way it conducted itself in terms of procuring external services for advice, etc. The next category, the second category of findings of fact I'm going to invite the court to look at are the findings that relate to the context in which the expenditure was incurred. Again, I'm afraid we have to dart around slightly because the findings are in different places. But if one looks at in fact, if one starts, please, the FTT findings, sort of at the paragraph 121 of the decision of the FTT, page 330. I would just invite the court to read that summary of the 4 stages that it identified regarding the transactions and activities in relation to Oxio. So prior to this point in time, the investments that were made by Coal in Oxio is a holding company.
When you say this point in time, do you mean June 2009? Or?
June, my lady. Yeah. So as at June 2009, the investment on the part of Coal took 2 forms. First was it held some shares in the holding company, and then there were a series of 4 subsidiaries. We'll have a look at that.
The Oxio holding.
The Oxio holding company, my lady. So it held the shares in Oxio, which had 4 subsidiaries, but it also held a number of loans in relation to it. And a criticism that I will make in due course of the approach of His Majesty's Revenue and Customs and also of the Court of Appeal is that it elevates the nature of the decision, in inverted commas, that was made in 2009 and draws a brittle edge as to what constitutes capital or income by reference to findings that weren't made by the FTT. One of the things that is also worth bearing in mind is at paragraph 219 of the FTT, page 352. The tribunal makes some findings regarding the ultimate effect of the transaction. That's not the effect of the services, I'm going to focus on that in due course, but what the ultimate effect to the group was of the transactions that were undertaken in 2011. Although the Eneco transaction, that's the one that occurred in 2011, did not involve the full disposal of Oxio businesses, it did result in Oxio BV selling via the partial demerger its customer business and other assets. This benefited Coal's investment business in 2 ways. First, coal's costs were reduced as it no longer needed to provide the financial support by way of equity and debt investment, which had previously done in order to try and stem the large losses. Secondly, coal received a substantial amount of money out of the proceeds of the transaction by way of repayment of its loans. An important point, which I will come to in due course, is that much reference is made in my learned friend's written case about the elimination of an onerous asset that was made. With respect to that case, it's not borne out by the findings of fact, because as the tribunal explains, and we'll see in due course, the principal asset that was causing problems in relation to the Oxio business was the tolling arrangement in the Netherlands in one of the subsidiaries. We'll have a look at that in due course, which we continued to own after such time as the Eneco transaction in 2011 went on.
You say at 219 that one of the benefits to coal was that the costs were reduced as it no longer needed to provide financial support.
My knowledge, yes. Yeah, I'd said that as well. But a point that I think is lost with respect in the Court of Appeal's decision is that they also lost sight of the fact that we continued to own the troublesome power plant in the Netherlands, and we'll have a look at that in a moment, if I may.
Yes, but his lordship's point is that certain onerous assets were disposed of, even if others were retained.
I accept that.
Yeah.
The third category of findings of fact, which in my submission in due course I will identify as being the key findings of fact, are those that the tribunal made in relation to the question as to what was the expenditure here in question incurred. We will see from the authorities that that is the fundamental question to which we're directed by the existing case law in this area. And the present turn is we know that the disputed expenditure, to use that phrase, relates to three sets of professional fees. The first was in relation, and these are set out in, we could turn to paragraph 426 to 428 of the STT decision on page 395. In the case of Deutsche Bank and PwC at least, the payments were made for services, that is, advice, and the advice was used to enable coal to make decisions about its investment in Oxio. In the case of Deutsche Bank, that was strategic advice on the options for disposing of this difficult asset and assistance in finding a purchaser who would be prepared to make an adequate offer for at least some aspects of the Oxio business. In my view, the cost of such advice were part of the ongoing management expenses, as it enabled the company to make decisions about how it might realize value from its investments in Oxio.
So was that the finding, that these are management expenses rather than the implementation mechanics?
Well, my lady, there are actually a number of findings that are made in relation to that. This particular finding's made in the context of the FTT's discussion of the capital expenditure issue. So I'll come back to some of the other points if it helps, but that is I submit a neat summary of the findings that it makes regarding what the nature of the services were. But there are a number of other findings that are made on that I can take your lady to now if you'd like me to. But this is by way of introduction, just to set the scene as to what they're finding in Deutsche Bank. There were, as my lady identifies, other findings made when we're considering the expenses of management issue, which is not under appeal.
Yeah, might have.
And the PwC advice We'll have a look at the deep dive report in due course. Was advice which gave the management of coal an insight into the nature and extent of the problems in the Oxio business and informed decisions about how to deal with its investment. Now, I will submit in due course that both of those findings in relation to the advice are the core type of management expense to which this relief is directed, and is not, on any view, capital expenditure in the context of the types of businesses here in question. There was, of course, a third amount of expenditure, which was occurred in relation to the lawyers, De Brouw. Now, the De Brouw position is, I'm afraid, slightly more nuanced than this. And the starting point is the finding that's made by the FTT at paragraphs 362 to 365 in relation to the De Brouw services.
The FTT addresses us at 429. Briefly, no doubt. That's quite useful to see.
Yes, my lord.
And just before we do that, at 428, the FTT make its finding about revenue rather than capital.
Exactly, my lady.
And the reasoning is really crystallised in 426 and 427.
Precisely, my lady. And I will come back to this because in my submission, what the FTT's findings did, and the FTT positively rejects the factual case that's advanced by His Majesty's Revenue and Customs in this court regarding what the expenditure was on when it comes to capital. Exactly the same points of fact as to what the expenditure was incurred on were put to the FTT. You can see that in paragraph 400. I'm going to come to this in detail. And what the FTT is saying is, no, this was advice on services that we used for the purposes of taking advice as to what to do about this investment.
Well, 426 says that Deutsche Bank was advising on the options for disposing of this difficult asset and in assistance in finding a purchaser, not what to do about it in a more general sense. That's what is said.
Well, my lord, we might need to look in more detail at the findings of fact that's encapsulated.
That's a sort of inaccurate summary, is it?
Well, I accept that is a summary of what was going, but it's incomplete.
I thought you said it crystallised the reasoning.
It does crystallise.
To the finding at 428.
It crystallises it, my lady, but the difficulty with it is these businesses, the advisory services that were received, covered all sorts of different things, and there are detailed findings that are made in relation to each of them in the context of the expenses of management aspect of the decision, from paragraphs 336 onward of the decision. And then what happens is...
So, I mean, the FTT does seem in 428 to be taking the view in relation to Deutsche Bank, but taking strategic advice on the options for disposing of the asset, assisting in finding a purchaser, is revenue, a revenue expenditure.
It does find that.
Without, I mean, we don't, in once... What I'm not quite clear is whether you're saying that it's because of more detailed findings about Deutsche Bank's role, that those more detailed findings support the conclusion in 428.
I see what I'm saying, my lord.
So that, I see.
The difficulty with it is, over the course of a number of years, each of these professional service firms did a number of different things. And even on our case, we accepted that from February 2011, the quality of what they were doing was different, because the focus was not what on earth do we do with this, or what is this that we've got. It was, here's a transaction, how do we execute it?
When was Deutsche Bank instructed?
Well, it was instructed in 2009, my lord.
In June?
Yeah. I believe it was June, my lord.
But was February 2011 then the cut-off between what was expenses of management and what was not, because it was the implementation, or was that the March date?
The cut-off there is rather, again, I'm afraid, rather more nuanced. The February decision was that we apportioned the expenditure to accept. We didn't advance any case on it not being capital for periods after February 2011. The point that's made by the Court of Appeal is that the expenses of management cut-off point, and if we could turn it up.
Well, the date was the Centrica board's approving the sale price,
Exactly.
the 22nd of February.
Exactly.
And after that date, you accepted you couldn't claim.
Exactly, my lady. But it was partly
Claim because they weren't expenses of management.
Well, I'm in danger of giving evidence in relation to it, my lady. As I understand the position and the basis of the concession that was made in relation to this, obviously the FTT resolves the claim that's made by the taxpayer in relation to it. No, it was accepted that the quality of the decision-making after February 2011 ceased to be expenses of management because it was concerned with the type of implementation expenditure which fell the wrong side of the line following Sun Life and CAMAS.
Sun Life addresses itself only to what they call inseverable expenditure. That's to say, where you've got, I think, stock exchange dealings, stamp duty and broker's commission.
Exactly, my lord.
But I mean, there might have been other advice taken before then, which would not be inseverable in the sense used by the House of Lords in Sun Life, would it?
My lord, I might be inclined to agree, but I'm not trying to defend the
It would be expenses of management, but the question would be whether it was of a capital nature.
Yes, my lord. And indeed, one can...
Isn't it right that quite a lot of the expenditure after February 2011 was on any footing expenses of management, because it wasn't inseverable expenditure?
I would submit...
But that's not how you ran your case.
No.
Your case conceded that they were not
Exactly,
expenses of
my
management.
And we
They were
don't,
the costs of the implementation of the sale.
Exactly, my
you know, we don't have to go
We don't, yeah.
to make any finding about what the state of affairs were after 22nd February 2009. We're looking at the intermediate period and the advice given by these three bodies to Cole in that period.
Exactly, my lords. But I am very conscious of the fact that this court has to reach a principled decision, and I recognise that the concession is, in some ways, perhaps odd, but it's a concession
You're not
nonetheless.
asking us, you're not seeking to withdraw that.
Absolutely not, my lady.
So the bucket of money that we're looking at is what is expenses of management prior to the 27th of February 2011.
Exactly, my lady.
Because as far as everything else after that is concerned, for good or for ill, you have accepted that is mechanics of sale and inseverable in a Sun Life sort of way, but that's not...
Rightly or wrongly.
Yes.
Okay, I said there was a nuance in relation to de Brown.
And you were taking us to 362, I think. Yes.
Yes, my lord. I apologise for, it seems an odd thing before the Supreme Court to be taking you to the facts, but in my submission, given the nature of the case law here, we have to anchor it in the facts. So this seems that, and this is where I say this Court of Appeal went wrong. Paragraph 365, one of the difficulties in relation to the de Brow fees, at this point in time, the de Brow fees were the fees of a Dutch law firm.
I haven't got the page.
Sorry, my lord. Page 384.
Thank you.
And if I could ask you just to read paragraphs 362 to 365. These findings are made at the end of the discussion in the expenses of management section. Now, what happens then is that some findings are made by the FTT regarding the de Brow expenditure, in 429, identifying that it was different in nature to the expenditure that was incurred in relation to Deutsche Bank and PwC. And the disposal of it is at paragraph 436, page 396 of it.
So the paragraph number is?
Paragraph number is 436, my lord.
Well, the competition law advice has to be specific to this particular asset, doesn't it? Because that will vary depending on which asset and which parts of it you're disposing of, as well as to whom.
And my lady's point is supported by the actual findings that are made, because 109 is quite clear that their role was to provide legal advice on competition law and tax, which might affect how the transaction was carried out, and produce and negotiate the documents to support it.
Precisely. And the reason I say that the position of this is nuanced is because if one then turns on to what happened before the upper tribunal in relation to this matter, sorry to dart you about, page 305 of the bundle.
Sorry, just give me that again.
I'm sorry, my lord.
Hey, could you just give me the
Yes, of course, my lord. 305.
305? Thank you.
Over the paragraph which precede this, the upper tribunal has recited the findings that were made by the FTT in relation to the de Brauw expenditure. And it summarises by saying that to the extent that the de Brauw fees were expenses of management because they informed decision-making in relation to the disposal of the business, it seems to us that they were revenue in nature, and the FTT was wrong to hold otherwise. They don't amount to one-off non-recurring expenditure, because decision-making in relation to Cole's investment business was an ongoing activity. What the upper tribunal did was to remit the question in relation to the de Brauw. If you remember, we looked at that passage from the FTT decision in which the FTT said, I can't tell, I don't need to resolve it because I've decided against the taxpayer anyway on the corporate plumbing issue. But if I needed to look at it, I would need more explanation between the parties as to what the actual services were you were paying for. And so it doesn't make detailed findings at that stage about precisely what the advice was that was received in relation to de Brauw. What the upper tribunal does is say, well, we haven't got the relevant findings that we need to find out whether or not the expenditure incurred on the de Brauw fees were on the revenue or capital side of the line. It needs to go back to the FTT, and on the basis of the evidence that's already there, and bearing in mind what we've said about the test, it needs to make findings of fact on that, in the same way it's done for the Deutsche Bank expenditure and the PwC expenditure.
But was that only the de Brauw expenditure before the 22nd of February 2000?
Yes, my lady.
Yes.
Yes, my lady. Now, what happened then is that the matter went to the Court of Appeal. And before the Court of Appeal, I'm rather labouring the point, but for the reason that simply pointing to a contract and engagement of services in 2009 and an invoice that's then rendered 2 years later, and saying that you can characterise whether or not something is revenue or capital expenditure by reference to the description in those documents, does not do justice to the trial that was heard on the evidence before the tribunal about what these companies were actually doing at the relevant times. And what the Court of Appeal did, when it came to them, was to decide against me on the Deutsche Bank and PwC fees, but also to decide against me on the basis of the De Brauw fees in circumstances where the FTT itself had found that it didn't have sufficient to make findings of fact as to which side of the line they fell on, and in which the upper tribunal had remitted it for that precise purpose. So it said, you don't just lose on Deutsche Bank on PwC, you also lose on De Brauw, despite the fact that the FTT hasn't made the relevant findings on these points.
Well, which findings are relevant depends what test you're applying.
I agree, my lady.
Yeah.
And absolutely, yes. And at one level, but in a sense, it illustrates my point that when we come to look at the historic cases on income or capital, a very forensic exegesis is required as precisely what the nature of the expenditure, what the services were that you received.
You're saying the FTT didn't do that?
Well, it didn't do that in relation to De Brauw. It did it in relation to PwC and Deutsche Bank.
I mean, if the Court of Appeal was right about Deutsche Bank and PwC, are you suggesting that De Brauw might be in a different position? No, I didn't.
I would accept that if I'm in trouble on Deutsche Bank and PwC, I'm stuffed on De Brauw.
Yeah. So, yes.
Okay. It's but I hasten to add that is simply because of the abstract nature of the test that was applied by the Court of Appeal, not because of any analysis of the services.
Thank you.
But what I'm not proposing to do, because the FTT didn't make findings in relation to it, is to take you to the detail of what De Brauw were doing.
Well, they made some findings. They made findings at 107 to 118, which look as though it was all to do with the transaction. They were only instructed after the decision to sell. Their fees were from an early stage to produce draft SPAs, draft term sheets, documents concerned with the detailed requirements for carrying out the transaction, Project Erasmus step plan, demerger.
My lady, I believe that the reason that point about the time apportionment that came in from the FTT is that De Brauw were actually instructed earlier than the point of the transaction, because the engagement letter, which is in the bundle, was from 2009. The question is, to what extent were the costs, if you like, of the services and the fees that were in question relating to exactly the category of expenditure that my lady identifies, and to what extent did they relate to services provided in the prior periods?
Prior to when?
Prior to February 2011.
Sorry,
No. You must mean prior to... No, anything after February 2011 is already established, is out. So the question is, what were these small amounts of De Brauw work that were done before that time?
And I think that I don't have the findings I need on those smaller parts, but my lady points to the points regarding the transactions that were there. But the FTT itself said, we will need to look at this in more detail.
Were De Brauw instructed after the board had made the decision in principle that Oxio would have to be sold?
I believe they were instructed 2 years previously.
Well, that's not what 107 says. 107 suggests the engagement letter is dated 9 October 2009 and says we're pleased to assist Centrica in regard to the envisaged divestment of the Oxio group with sale of shares and or sale of business or pursuant to an auction sale. That sounds like it was an instruction specific to the Oxio transaction.
Yes, from 107 to 118, one has a description of the engagement of De Brauw and what they did.
Yeah.
And no doubt that's what the Court of Appeal relied on.
It may have done, my lady. I don't know what it relied on because it doesn't set out its findings on that. But May I come back to this in a moment? Because I think that the point I was about to move to was that whatever the findings are in relation to De Brauw, the findings that really persist are those that relate to Deutsche Bank and PwC, where the FTT, the upper tribunal and the Court of Appeal rightly acknowledged that there were findings in it. We haven't got an Edwards and Bairstow appeal on either side of this case. So if those findings were sufficient to support the Court of Appeal, that may be something for my learned friend. But
Well, as I understand it, what the Court of Appeal said basically was these findings as to De Brauw, plus the acceptance that the disposal of Oxio was the disposal of a capital asset, mean that this expenditure is an item of capital expenditure, and so not included. But you're saying that those two facts are not enough to determine the case.
no, my lady.
Because
Because we need to look at precisely what each of these companies was doing in terms of the services and what the use that was made by the business of them was. I can illustrate it most closely by reference to findings that were made on Deutsche Bank and PwC, rather than by reference to De Brauw. I absolutely accept De Brauw is much harder for me, but at one level of abstraction, the Court of Appeal say, once you've made, in inverted commas, a strategic decision in June 2019, I'll come in due course to unpack what the quality of that decision was and what it was that was made. Everything which you incur after that point of time was connected to a capital disposal, albeit not one made by you, and therefore it's capital. And so, in a sense, an analysis of precisely what X lawyer was doing at this date or otherwise is academic, because it hangs its reasoning on that June 2019 decision. But if we look back at the findings that were made by way of Deutsche Bank, I'll submit that these are the kind of findings that you need to ascertain whether or not a given level of expense is revenue or capital, as we come to look at the authorities. So between 337 to 34 up in
paragraph or page are you looking at?
no, it's page 380, I think.
3, what, sorry?
80.
Like, hold up, those aren't, are those
Those are in the expenses of management bit.
Those aren't the findings about what Deutsche Bank was doing are much earlier, aren't they? They're 71 to 73.
Yes, there are those.
87 is the data room. 91 is the key transaction and terms. Why are you looking at the conclusions? I thought you were taking us to the findings of fact.
Because the findings are, respect, darted all over the decision, my lady. Those are undoubtedly findings.
Okay.
There are also...
They are what tells us what Deutsche Bank's engagement and role was from the date they were instructed.
Yes, my lady. But also, if we look at Deutsche Bank, on page 380, the FTT expressly recites exactly the passage my ladies pointed to a bit earlier, paragraph 61 onwards.
But it's all directed to the transaction, isn't it?
Well, with respect, my lords, the difficulty with it is the transaction at the point in time at which they're doing this work didn't exist.
Well, you say that, but a decision had been made in June 2009 to realise this investment.
If possible.
Of course, if possible. And in 337, the FTT says that Deutsche Bank's main roles were to advise on strategy and tactics in relation to structuring the transaction. That means the intended disposal, including advising on identifying potential purchasers and so on.
But if one looks back at the decision that's made in June 2009, The transaction, in inverted commas, encompasses the possibility that they might do nothing with this asset. The transaction is used as shorthand.
You say that, but I thought it was presented in the accounts of Centrica as a discontinued business.
Held for sale.
Exactly.
Sorry?
My lord, it is presented in the accounts as a business, but there was a lot of evidence as to what that meant, and it's an accounting term of art.
I see.
And indeed, there's some findings that are made in relation to that in the FTT decision. There was.
Well, then the main point then is what was the what the FTT talks about here is the transaction. Well, not doing anything isn't a transaction. So it looks as if the decision in principle has been taken to realise this investment, and that's the transaction that they're referring to. I think you're saying that is simplifying the position.
It is, right.
And that actually well, I'm not quite sure exactly what you are saying as to whether a decision in principle had been taken in 2009 and what it was that Deutsche Bank's role was.
Well, as to the first point of raise, the decision in principle that was made, it's described as a strategic decision, but on page 330, that passage I asked to look to a moment ago in paragraph 121,
Quite.
Yes.
I mean, that rather makes my point.
Yes, it is.
well, then, I'm sorry, my lord,
I mean, I'm not saying there was or there was not a strategic decision to sell the Oxio business. That decision taken in June 2009.
there was, my lord. I don't shy away from that, but that was not a decision to sell it to Eneco on the terms that
No,
were
of course
provided
not, because we know. Yeah, but I think you were suggesting it was something other than, less than, a decision to sell. It was still reviewing the options, as it were, rather than having decided, well, in principle, if we can, we're going to sell.
Well, are they mutually exclusive? My understanding of your position is that there was a strategic decision to sell, but the advice around that decision included the option of not selling.
Exactly, my lord. And the other point in relation to it is this is not selling a liquid marketed security on an exchange. The evidence that was before the tribunal.
You would be in a investment trade.
Well, I'd be trading anyway, but yes, I wouldn't be.
Your point is that there may have been a decision to sell the Oxio business, but what that meant wasn't at that time clear.
Exactly, my lord. And also,
I'm still not clear about this, I'm afraid, Mr. Rivet. I mean, I can understand the board taking the decision to sell. I mean, obviously, if possible, it might not find a purchaser. What I'm unclear about is the extent to which you're saying that the board retained, as part of its strategic decision-making, the possibility of retaining the business.
I am saying that.
You are saying that was part of it. So this is an incomplete statement, really, in 121. And that's fine. I just want to...
Well, it's sort of fine, but you just said we haven't got an Edwards and Bairstow challenge here. So we are bound by the findings of fact made by the FTT.
Yes,
and the FTT record at 121 that there was a strategic decision to sell the Oxio business.
Yes.
In 2009, and that was the first stage of a 4-stage process.
And she says that, it's not going to sell at any cost. This was a bottomless pit into which Centrica were throwing money, and they decided they weren't going to throw any more. But they might not have been able to find anybody to buy it.
Exactly, my lady. And if you look at paragraph 128, you see quite what is meant by what happens after this. Although Centrica would have preferred a share sale, they considered all the possible options throughout the period of the transactions.
Well, yes, but that reads as if they're possible options whereby the investment can be realised. I mean, obviously, there are lots of ways in which you can dispose of an asset, short of actually transferring legal title to that asset. I mean, clearly, there are lots of ways of structuring a corporate transaction. That doesn't suggest anything other than where our decision is to dispose, if we can, of this asset.
My lord, yes. But then look at what is said in 128. Mr. Ford said the sale process was put on pause pending the outcome of PwC's deep dive, and a further possibility was to retain the business, deal with the problems, and then try to sell it. I absolutely accept that a strategic decision was made in June 2009 that they wanted to deal with this asset. But what happened is the path did not run easy, even by the standards of these sorts of transactions.
Well, that might suggest that the PwC report was not directed to
Precisely.
a decision to sell, but was actually sort of retracing steps a bit on that.
And that's what they're saying is when we come to look at the
That's
findings
PwC, but that's not necessarily Deutsche Bank.
from my lord,
Because Deutsche Bank presumably would be put on hold while PwC did its deep dive.
well, actually, Deutsche Bank with the development. The difficulty with this is the evidence on it went on for days, and there's some findings about what my lady had the passage regarding what Deutsche Bank were doing. And if you look at pages, there are detailed findings in paragraph 61 onwards. But if you look at page 322, for example, regarding what Deutsche Bank were doing,
Paragraph?
paragraph 71, my lord.
Well, but none of that is inconsistent with attempting to taking the decision to sell, which had been taken in principle, that's what's said, and advising how best to structure it. And if you can't sell, well, we'll have to shut it down, is what they're saying here.
I accept that, my lord.
Well, it's all directed to the disposal of the asset.
If possible, in some way which may be ascertained.
Yes, 71 is perfectly consistent with 121 because the last sentence of 121 indicates that at times it was thought that they wouldn't necessarily be able to implement their decision in principle. But I wouldn't be able to sell the business at all.
And then there are more findings about the deep dive at 103, which appear to suggest that the investigation was to identify whether the business was unsellable.
Sorry, Ed, what was the
103.
103?
But then the points when the tribunal comes back to consider all of these in the context of its decision on the capital issue, what the tribunal says is this is what this business does all the time. It's looking at its investments and trying to ascertain, take advice on how to realise the best value for them. That's part of the function of an investment business such as this.
Oh, is there evidence of other occasions on which Deutsche Bank or similar institutions were engaged to advise on disposing of Oxio?
Yes, my lord. I think I referred to the
Other occasions, looking at Oxio?
Oh, on Oxio, not on Oxio, my lord.
No.
But
Are there other occasions where you've got a loss-making business that you want to dispose of? That you say this is the daily diet of the business. I was wondering where the evidence of that is.
Well, there's some passages that are found in relation to that in the FTT decision, my lord. Perhaps I should answer it by reference to that.
But why then do you accept that this was a capital asset being disposed of?
Why do I accept it as a capital asset? Because I accept that the shareholding and the investments were capital assets of the businesses. They're investments.
Yes, but at the same, if you're a farmer and you buy a tractor, that is a capital asset for your business. If you're a tractor seller and you buy a tractor,
You're trading in tractors.
You're trading in tractors, and that's your stock in trade. So that's the distinction that we're talking about here. What is the character of the tractor as far as this business is concerned? Now, the holding in Oxio is that the farmer holding that, or is that the tractor seller holding that? I thought, but I may have misunderstood, that by accepting that this was a capital asset being disposed of, you were accepting that we're in the farmer's tractor rather than the tractor seller's tractor.
In other words,
Box.
we're not buying and selling company shareholdings.
No, we're not, my lady.
And that would be the
We're holding them for investments. And I mean, there is a possible. I mean, part of it goes back to those old distinctions between fixed and circulating capital, but then they don't work in the context of this type of business, because clearly these are different to, for example, the headquarters from which the fixed capital in the sense of the headquarters in Windsor from where we run the business. Clearly it's not that. But we accept that the assets, the investment in the shares in Oxyay, together with the loans, were, as it were, capital businesses of our investment. That's why we are an investment holding. We hold them to realise value from. And that value may take a number of different forms. It may take income yield, it may take sale at a profit. But it is different from, with respect to the farmer analogy, because it goes back to all of the cases on it, the danger with analogies. But the farmer and the tractor trader are trading.
Well, I mean, the distinction, I suppose, is it's not really what a farmer doesn't manage the tractor. He just uses it in the management of the farm, in the farming. That's the distinction. But the core point made by my lady is right, and you accept it. That these are capital assets.
Yeah.
So when you dispose of it, you make a capital, not a revenue profit.
Absolutely, we accept that.
Or loss.
Yeah. In a sense, it comes back to the point, the difficulty with this particular code, which we'll look at, is that it falls in the grey area. Because if we were a trading business, and we were holding these as trading stocks, we'd be deducting them on the cost of the acquisition, or otherwise. No, that's not what we do. And that's why the relief was introduced in the first place. And there's a really good explanation of all of this in the judgment of Mr. Justice Patton in the High Court in Camas, where he set up all of this, with respect, extremely clearly, the difference between how the trading company and an investment company works by reference to those earlier cases relating to the origins of the reliefs.
Yes. We better let you develop your arguments.
What I may do is, I'll invite the court. I was going to turn to the findings that were made as to what the advantage was that was secured by these various services, but I think what I may do, if time allows, come back to that in due course and turn to the law, because I'm concerned about. But I'll come back to the findings in a moment. So we have 2 points, two principal points regarding the construction of this legislation. I wonder if I might ask the court just to start by turning up the legislation. The bundle contains, this legislation has gone through a series of different iterations over the years. The relevant legislation, for present purposes, commences at 1091 of the bundle. And if I could ask you to turn. I was going to invite the court to look again at the judgment of Mr. Justice Patton in Camas, if that would be helpful to the court at this stage, just to set in context how this legislation operates. But it may be that that's something that doesn't need to be done orally, is it? I don't know, is it? Right. So the release that we're concerned with starts on page 1117. And the point that's made in the authorities regarding the origins of this relief, which is set out in our written case in some detail, is that what this relief was introduced to do, in the first instance, was to put, as it were, businesses which carry out investment business on an even footing with those who carried out trading businesses, because the difficulty with those who carry out investment businesses at the time at which it was first engaged was that you got no relief for the normal day-to-day expenditure that was incurred in running your business.
That was because tax was deducted at source, isn't that right, from the income? Is that the reason?
Part of it, my lord. In fact, why don't we...
I mean, I don't want to spend... your time is very limited, but
That's part of it, my lord. It's because in the context of a trading business, so
I mean, where with an investment holding business, if you were being paid dividends, the tax was deducted at source. That's my understanding. Yes. And that was the background in 1915 to these provisions being introduced.
It was also that background coupled with, in the context, you see it explained in Sun Life, in the context of life assurance businesses, that there was an election that could be made by the tribunal, by the inland revenue, as to whether or not you were taxed as a trade on your investments or otherwise. And in circumstances where you weren't taxed as a trade, it led to a disadvantage because your expenses of management could not be deducted. This is set out in some detail in the judgment of Mr. Justice Patton in Camas. The difficulty in here is that in these circumstances, an investment company is taxed both on its income and its gains, by common with every other company that's there in question. But the difficulty is that absent the expenses of management code, if we buy a business or shares, absent the provisions of the expenses management code, we would not get any relief for the costs of that acquisition unless and until such time as we sold it post-1965 and received a capital gain for it. At that point in time, the capital gains tax code would allow us to deduct the cost of acquisition of the investment and certain categories of expenditure that were incurred in relation to it, limited. We may never sell the investment. Now, this regime was put in place before 1965, so we're dealing with a world in which the capital gains tax regime is not in place. But the hinterland of in which this business operates is such that the expenses of management code is, I think that it will give us relief absent the expenses of management code if we'd sold Oxio itself. We didn't sell Oxio itself. And we'd incurred certain limited categories of deduction in computing the gain of that. But in these circumstances, we claim an expense of management. And just looking at...
I mean, expense of management would not be deducted in the capital gain.
It would not, I think. There's an express provision, actually, which if you turn back in your bundle, the provisions of section 39, subsection 1, we present out. The scheme of the code here, if we want a quick look at it, one of the difficulties with construing Part 16 of the Corporation Taxes Act 2009, where these provisions are now put, is that in addition to the core expense of management relief, which is identified in paragraph 1219, with which we're concerned, there's also a group of types of expenditure which on the face of matters might not constitute expenses of management, but which are deemed to constitute such for the convenience of parking this expense in a particular part of the chapter, and that's chapter 3. So we're concerned with section 1219. In calculating the corporation tax to which a company with investment business, that's us, is liable for an accounting period, expenses of management of the company's investment business that are referable to that period are allowed as a deduction from the company's total profits. And the total profits is identified by Section 4 of the Corporation Taxes Act 2010. I don't think we need to turn up.
That's profits and that's
Income and gains.
profits and capital gains.
Exactly. And this is a point, again, that's dealt with in some detail by Mr. Justice Patton. Prior to the provision with which we're concerned, there was nothing in the code which made any reference to expenses of a capital nature. And what we had, however, was a definition of what was meant by expenses of management, which came from Sun Life, and which is the subject of the consideration in CAMAS. And if I could ask at this stage, please, to turn to Sun Life, because I see that the construction of what constitutes an expense of capital nature in these circumstances has to take account of the context in which in which Sun Life was decided. This is at page 1411. If I could ask the court, please, just to read the head note.
Sorry, I think I've got the wrong page.
Sorry, my lord, it's 1411.
I did, yes, got it slightly wrong.
I think your lord indicated that he was familiar with this anyway, but
A little bit.
Dad. So this case was concerned with brokerage and the stamp duty that was payable in respect of the investments there in question. And if you can turn to page 1424. And Lord Simons. Lord Simons at the bottom of that page. You could see at the bottom, records the decision of the special commissioners and who say, in our view, the disputed items are so closely linked with the transaction of purchase, being necessarily incurred in the course thereof, as to be considered part of the expenses of the purchase and not expenses of management of the society's business. And the next passage that comes on page 1425, please could I ask the court to read that first paragraph, because the point that's recorded there is that it was a concession that, in that case, that the investments themselves were not expenses of management.
So those would, well, there was no capital gains tax in this.
There's no capital gains at the end.
Concession has informed the position for many years.
My lord, it has.
notwithstanding the doubts expressed by their lordships.
Exactly, my lord. I think, my lords and ladies, you have the point.
It's slightly odd, or not that relevant. Lord Simmons refers to it as the necessary stock in trade, which is a odd term to use. We're talking about an investment holding.
It is, I agree. But they're dealing with the life assurance business here.
Which we're buying and selling shares.
Yeah, exactly.
Yeah.
To support its policies.
Yeah.
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 So we're dealing with it to support its policy. So it's a different set of circumstances.
Yes, so they were clearly regarding it, the reference to stock in trade, as there would be revenue expenses if they were seeking to apply the distinction that we were.
Yeah.
It's more like farmers selling the tractors.
Is that, or tractor merchant?
So again, the tractor.
Tractor merchant.
Is that?
And what Lord Simons goes on to do is to allow relief in respect of the brokerage, but not the stamp duty.
I thought that was Lord Reed's position.
Sorry, that's what Reed's position. Sorry, I was going to come. But in a sense, the point is not the extensive management concession. It's simply the point. The building block of what happens over the next 40 or 50 years is the acceptance that the cost of the acquisitions of the investments themselves was not an expense of management for these practices. And then there's an analysis of severability that goes on. If we then turn to counts, which is the occasion in response to which this provision is enacted. This starts on 1831. And again, if I could just ask Court just to look at the first two paragraphs of the head note. If between pages 1856 to 1858, Mr. Justice Patton makes the observations regarding the scheme of the legislation. Now, the legislation has been rewritten since this point in time. The fundamental principles I respectfully submit and why, just as to how the legislation fits together for the taxation of investment companies or companies in investment business. if we turn on, there's then a number of submissions which are really focused upon the question as to whether there existed a freestanding implicit capital bar in the expenditure here in question. And then what happens is from page 1869 to 1871, Mr. Justice Patton rejects the approach of the special commissioners.
What's he rejecting?
He's rejecting, my lord, the analysis in particular at paragraph 43 that the special commissioners applied to Sun Life. If one is a summary here, in my judgment, special commissioners have misapplied the Sun Life test to the facts of this case and appear to have asked themselves a different question. The speeches in Sun Life indicate that the correct approach is to draw a line distinguishing between management expenses and expenses or costs which are properly to be regarded as the costs of acquisition, i.e. the purchase price. And expenses, to use Lord Reed's word, severable from the cost of acquisition. If objectively viewed, it's not part of the purchase price. That's a matter of judgment. Does not follow merely because expenditure which predates a possible or actual acquisition was prerequisite to, or to use the special commissioner's word, directed at the acquisition, but it automatically falls to be regarded as part of the cost of acquisition. The logic of that view would mean that any expenditure relating to a management decision to invest would be disallowed on the basis that it was an essential part of the process leading up to the acquisition itself. He then goes on page 44, to say that the correct answer to Lord Reed's question is that the expenses under consideration in Camas are not part of the cost of acquisition. On the Special Commissioner's own findings of fact, the services of Schroders and the other professionals were needed and were used in order to obtain advice on a possible investment in the form of the acquisition of the Barden Group and to decide whether to go ahead. The work stopped when, on advice, the decision was taken to abort any possible acquisition. But even if the acquisition had gone ahead, the nature of the services would have been the same. Although one element of the professional services involved in working up at the bid, Mr. Reed's evidence indicated that this was part of the decision-making process, and the commissioners accepted that. I submit that that's, with respect, what's also going on in our case.
But this is all directed at whether they're expenses of management,
It is, my lady.
not whether they're capital expenses.
It is.
We're in a situation where they are expenses of management, but the question is, do they fall within the carve-out?
Exactly, my lady. But the context in which, as we'll see based from the timing of the introduction from it and from the materials upon which my learned friend relies, it was this judgment that provoked the introduction of the capital bar.
Yeah.
Yes, because the revenue were arguing that there was an implicit capital bar, and Mr. Justice Patton and the Court of Appeal said there wasn't.
Exactly, my lord. And the point that's made by Lord Justice Carnworth, when it gets to the Court of Appeal, is that in his respectful submission, not in his respectful being right, what he's saying is that once you've properly understood what it means to have an expense of management within the test that's identified in Sun Life, there may be little room for capital anyway. It's difficult to identify any category of expense which incurred by somebody who is properly identified expenses of management on that test as amounting to capital in law. And you can see that on page 1886.
And at 180.
By page again, please.
1885 to 18, it's where the relevant exclusion capital begins.
passage you want us to look at?
Well, he identifies that the finance bill, with some prophecy, has introduced new capital distinction into C, my lord.
Which sorry?
Sorry, I'm lost.
Yeah, I'm also.
I'm so sorry. 1886.
1886.
Yes, it's the end of paragraph 39 that he refers to the finance bill.
Exactly. And then he goes on from paragraph 41 and 42 to go back to Sun Life. And he recalls at paragraph 42 on page 1887 the submissions of the Attorney General in the following terms. If it was possible to have a capital expense of management, which is doubtful, there'd be nothing in section 33 to exclude it. And in paragraph 44, again, it is a short point. In agreement with Mr. Justice Patton, I see no reason to read words into the statute which are not there. Indeed, I'm content to adopt the way in which the matter was put by the Attorney General in Sun Life.
How do you paraphrase what he's saying here then?
I paraphrase it in the sense it only takes me so far because I paraphrase it by saying that once you have correctly identified the nature of the businesses to which this relief applies and what they do, they make, acquire, hold, sell investments, and you've identified what constitutes an expensive management in that context as including advice taken in relation to whether to make, hold or sell investments, then in those circumstances, that's the core of the relief, and it would be surprising if you would identify expenditure on that kind of advice as constituting capital. What Lord Justice Conworth is saying there is the Attorney General accepted that it would be surprising if you could have something which was a capital expense of management, given the nature of what constitutes an expense of management in these businesses in the first place.
I'm just not quite sure what the Attorney General was presumably acting for the revenue.
He was.
You can read that for if it were possible to have a capital expense of management which is doubtful. Seems rather consistent with the revenues argument in Camas that you cannot have a capital expense of management.
Well, that may, in any event, I think, Lord. Well, here we do have an expense of management.
Yes.
That being the case, that would be an argument in my favour that having provided that these are expenses of management in the sense identified in Sun Life, they can't be capital.
Well, except
because
now the statute says
You can do it.
Yeah.
You can do it. But that, in my submission, goes to the point why what this is really directed at dealing with is a narrow, limited category of expenditure in the context of these businesses.
Well, why do you say that?
Because at one level of abstraction, my lord, everything that these companies do is connected to a capital.
No, with respect, that can't be right. I mean, a holding company is constantly concerned with the management of its investments. I mean, this holding company, being an intermediate one, doesn't seem to have much of a life of its own. But let's take, the Centrica PLC at the top. I mean, it will be taking constantly many decisions in relation to the group, none of which are directed to buying or selling companies within the group, but are concerned with its role as the controlling, indeed the only ultimate shareholder, in what is to happen in the group. All that is the revenue activity, if you like, of an investment holding company. So, I mean, a group whose underlying business is like Centrica, which has a huge business other than holding investments, is concerned with managing that business, which is held through the investments, and that is the ultimate function of the holding company. Of course, from time to time, it's going to be buying and selling investments. Subsidiaries, and so on. But to suggest that that's the bulk of what a holding company does seems to me, with respect, quite wrong.
But an investment company, my lord, I mean, by definition, it is holding investments and
it's holding them. It's business. It's revenue business, if you like, is holding investments. Its revenue business is not buying and selling, because that's what an investment trading or dealing company does. What I'm slightly taking issue with is your suggestion that the bulk of the activity of a holding company is directed at acquiring and disposing of subsidiaries.
Well, the FTT made findings on this, my lord.
Well, if you like,
about the activity of our business.
I'm happy to see any, obviously.
But also, could we go back to the legislation, and in particular?
But if its business was buying and selling shareholdings, then it wouldn't be an investment business.
If it was trading,
But yes.
it might not be, depended upon whether or not it was trading in relation to.
But wouldn't that still be caught by this provision? Aren't there really two sorts of investment businesses? One where their stock in trade is buying and selling, and they're constantly selling shareholdings and buying other shareholdings and getting dividends and making money on the spread. But then there are also this kind of investment business where it's actually an energy supply company overall, but to do that it holds these energy supply businesses.
Well, the group supplies energy, but it does all sorts of other things as well, my lady. What we're concerned with is this company, and some help is given in this regard.
Just to be clear about this, it's section 1218, isn't it, that defines an investment business, and that means a business consisting wholly or partly of making investments. And I had read that as not including buying and selling investments. So that, but maybe wrongly, but I assumed that a business, this was directed at investment holding businesses, not investment dealing businesses. That's what I had assumed. If I'm wrong about that, please let me know.
But the definition of an investment business, of which we are one, is a business which consists wholly or partly of making
investments, which means acquiring with a view to holding.
Yeah.
Yes.
And you get more of that from section 1219, subsection 2.
Okay. Yeah. Yes.
Yeah.
Should be.
So the first way we put our case is that insofar as one can't just transplant wholesale all of the authorities that were decided in the context of trading cases into the construction of 1219(3) to ascertain what's meant by capital expenditure. One has to do it in a way that recognises that the nature of the business here, a core element of it, will be taking advice on those investments. And that taking advice in relation to those investments, as the FTT found in its findings, was at the very heart of what this business did.
So what was the just the reference for that?
I'll get those for you. I'll take you to them in open.
Did you? Well, just give them to me later. Don't worry now.
But if we then, in fact, we can turn to this anyway. If we turn to the FTT decision, and turn in particular to page 390. Yes. Which is paragraph 400.
Paragraph 400.
Yes, why not? Mr. Henderson's case, because we're about to lead into their second construction of this, is the deal with Lord Richard's question about what the findings were as to the nature of it. Mr. Henderson, who was the counsel for the Crown at the first instance, submits in Cole's case that the disputed expenditure was not recurrent expenditure to meet a continuous demand of management of Cole's investment business. It was something that was incurred once and for all in order to dispose of an onerous asset, the Oxia business. It was incurred to effect a capital disposal, and that should therefore be on capital account. The FDT then goes through the authorities, which I will go through extremely quickly in a moment, but then says on paragraph 407, in summary, Mr. Henderson relies on these cases.
Sorry, paragraph 407.
407, page 391.
Right.
Mr. Henderson relies on these cases as establishing that incidental expenditure on a capital transaction is itself capital in nature, whether the transaction goes ahead or not. He then submits that the disputed expenditure is expenditure incidental to the capital transaction, which is the disposal of the Oxia business. It is a similar question he submits to whether expenses are expenses of management or cost of acquisition disposal, although different principles apply. The FDT then goes through my submissions, and at 420, they record a submission from me that the bar cannot apply to all expenses or the relief without little benefit. Records that Mr. Henderson didn't go this far, and then says the question is where to draw the line, and HMRC seek to draw it at a point where a company decides to sell the asset, which in this case, it is argued, is when Centrica declared its strategic decision to divest Oxia business. I found that was much too earlier point in considering whether the disputed expenditure was an expense of management or expense of implementation. Then we go through the passages that we looked at.
That's confusing the two tests, isn't it?
Yes, well, I think it is confusing them, but also,
Well, it's not commenting on the capital issue there. It's commenting on the sunlight.
the line, exactly. Yeah.
Well, what she's saying is that's too early a point for the divide between expenses of management and the mechanics of implementation.
Precisely.
Yeah.
It may be the right cut-off to decide whether it's a capital or a revenue expense of management.
Exactly. And then on page 422, paragraph 422, the FDT says this: the management of investments involves buying and selling investments, possibly doing things to maintain and support their value, and importantly, considering how to maximize the value of the company's funds, which might involve acquiring new assets or disposing of other assets. An investment company might dispose of an asset to crystallize a profit or to limit the loss on an underperforming investment. It will require advice to assist in the management, and that may be provided by an internal team or an external institution. Then goes to refer to those different points. And then we come to the passage that the conclusions in relation to this. Paragraph 426. In the case of Deutsche Bank and PwC at least, the payments were made for services, that is advice, and the advice was to be used to enable Cong to make decisions about its investments in Oxia. In the case of Deutsche Bank, that was strategic advice on the options and assistance in finding a purchaser. In my view, the costs were ongoing management expenses as it enabled the company to make decisions about how it might realize value from its investments. The PwC VDD report, and in particular the deep dive, was advice which gave the management of Cong an insight into the nature and extent of the problems in the Oxia business and informed the decision about how to deal with its investment.
All this can support a finding of expenses of management, but how does it tell us anything about whether it's capital or revenue?
Because, my lord, what it shows is that in order to have found that it was an expense of management in the first place, the services had to be used for something which was the management of the asset in relation to it. And that being the case, I will submit in due course on the trading on authorities and otherwise, this constitutes revenue expenditure. And I recognise that this may mean that the overlap between the identification of a category of expense, which is an expense management of a capital nature, may be quite thin. There may be only limited examples of it.
What do you say, or is this something you want to come on to? What do you say that the introduction of subsection 3A achieved for the revenues?
Well, with respect, I say it achieved relatively limited amount, my lord. What I said it achieved was to make clear that if and to the extent that following counts, there was any doubt about whether or not the cost of investments themselves might be expenses of management, or that in the word capital, they were excluded. But more obviously, it excluded things like the cost of the acquisition of headquarters from which we conduct our business, that kind of fixed expenditure.
But there was nothing in CAMAS to throw doubt on that, was there?
Well, the width in which Mr. Justice Patton expresses himself regarding he says there aren't bright lines on which you can draw identification as advice as to whether or not it's inseparable or otherwise from the cost or sale of the investment.
But, I mean, his decision was consistent with and applied the Sun Life approach.
It's right.
I mean, wasn't this this amendment designed to deal with the rejection of the revenue's other argument?
Yes,
in CAMAS? Yeah.
it was.
I mean, they needn't have done anything if they were happy to live with the Sun Life position. They obviously wanted more than that.
They wanted more than that.
And the question is, what more?
And then the question is whether or not, in fact, CAMAS, on the facts that were found by the FTT decision, by the special commissioners in that case, whether CAMAS itself would have been caught.
That's a question, fortunately, we don't have.
Yeah. But that's a different question. Obviously, it's a different business to these sets of circumstances. But a different question is whether or not the amendment that the revenue promoted to the regime would have had the effect of enabling them to win in CAMAS.
The question is whether it does have the effect of enabling them to win in this case.
Exactly. I think in the time left, I should deal with the trading authorities.
Yes, please.
And what they do and don't say. My Lord, the difficulty with each of these authorities is that there is an intrinsic, it may not be described as such, but there is an intrinsic temptation to try and fact match. And the only fundamental principle that you can draw from any of these authorities is that there is no bright line that can be drawn from any of them. I've attempted to distill these into 9 principles. I hope most of these should be uncontroversial. First, although some of the earlier authorities suggest otherwise, the question of whether given expenditure constitutes a revenue or capital expenditure is a question of law. And you get that from Beecham and Woolworth. Second, there is no single test which will be decisive of what constitutes capital or revenue expenditure. And that's made clear by Lord Wilberforce in Strick and Regent Oil and affirmed by Lord Fraser in Tucker. And in this regard, as is made clear from Tucker and Granada, the courts have repeatedly emphasised that you shouldn't seek automatically to apply the words or formula which have been found useful in one case to another set of circumstances.
Well, that must be right, yes.
Well, third, the transaction should be looked at against the general commercial background of the taxpayer's business. See Lord Wilberforce and Strick. Fourth, having understood the general commercial background, the modern authorities do not look at the purpose or motive of the expenditure, but instead seek to identify what the expenditure was incurred on or what was obtained for it. And in this regard, Tucker says something slightly different to Atherton, which is dealt with.
So if you just look at what the expenditure
Was incurred on. What did you get for it?
Thank you. And Tucker says something different, you see.
Well, Tucker says that, my lord. Tucker says, to the extent that some of the earlier authorities, Atherton, etc., had looked upon the purpose or motive of the taxpayer in trying to expend something. And what Tucker says, and the other authorities, is that really you look at what was the advantage you got from telling it, what's the object, if you like, of the expenditure. And I will submit that, in due course, that one of the difficulties in this case is that the Court of Appeal confused really what the purpose of obtaining advice was from what the advice actually was and what it was used for on the findings that were made. The fifth principle is that for expenditure to be capital, it needs to be spent on the acquisition of an asset, the improvement of an asset, or the disposal of an asset, and there are lots of authorities on those. 6. And this is Johnson-Matthey. Contrary to the decision of the Court of Appeal in this case, it isn't sufficient that expenditure is merely paid in connection with the acquisition, improvement, or disposal of an asset. The connection needs to be closer than that.
Well,
7, and Tucker makes this clear, it's always necessary to identify a specific capital asset for which expenditure is incurred in those category of cases, and that's Tucker and Granada motorway. The asset might be tangible or intangible. Where the asset's tangible, it's usually straightforward. Where it's intangible, it's less straightforward.
It's always necessary to identify a specific capital asset.
Yes, my lord. 8. All business expenditure is intended to procure some form of commercial advantage, and where the expenditure is on an intangible benefit or advantage, such as some of the trading agreements or licenses that you see in some of the authorities, you then have to ask a secondary question to ask whether that identifiable asset is of a sufficiently substantial and enduring nature to count as capital, and that's Anglo-Persian oil.
The asset is of a sufficiently
Enduring.
There's lots of case law on the question of whether a particular advantage is enduring or otherwise.
And the case, sorry,
That's Anglo-Persian oil, my lord. Ninth and finally, the liability of expenditure to recur is indicative of the expenditure being revenue expenditure rather than capital expenditure.
yeah.
We develop in our written case 5 principal reasons positively why the expenditure in these circumstances was not capital on the existing principles. I don't propose to look at those in detail at this stage, or I don't have time to, but what I would do is ask the court at this point to turn up one authority which wasn't considered.
Could you give us the page numbers of your case that you're funding on there?
Sorry, my lord. Yes, of course.
The page number of the case.
They're dealt with our submissions on this, our written submissions in relation to it. It's dealt on page 107.
Page 107.
Page 107, my lady. And page 110.
Thank you.
Paragraph numbers.
Right, yeah. Actually, it'd be helpful to have the paragraph.
Check my head there. Paragraph 114 to 149.
Thank you.
But also the errors are set out of the Court of Appeal after that, which I'll just look up in a little more detail in a moment if I may. But the authority that I wanted to show there before is Johnson Matthew. And you'll find that page 1660.
So what's the page number again, please?
Page 1660, Myland.
Thank you.
Okay.
You're very shortly going to be eating into your reply time, so
Sorry, Myland.
don't apologise. I just draw that to your attention.
So the simple point, my lords, is the point made on page 1700. The facts of the case are set out in the headnote. And what's said there is, it's important to observe the payment does not become a revenue payment simply because Johnson Matthey paid the money with the purpose of preserving its platinum trade from collapse. That was the approach of the General Commissioners, which I do not feel able to accept.
Whereabouts are we?
Page 1700, my lord, by paragraph D.
B or D, did you say?
D, my lady.
Thank you.
As the characterisation doesn't depend on motive, that's your point.
The motive or purpose of it. Here it depends upon the question whether the sum was paid for the disposal of a capital asset. I've come to the conclusion that on a true analysis, the sum was not paid for the disposal of the shares. It was paid by JM plc as a contribution towards the rescue of JMB, which JM plc knew the bank was going to mount immediately in the public interest. As such, it was, in my opinion, properly characterised as a revenue payment.
Just it.
Now, if one turns previous to the Court of Appeal decision, so page 248,
Seven.
That paragraph?
paragraphs 95 to 107. And in particular, turn to 104 to 107. You can see the summary of what the Court of Appeal decides on this point. The crucial feature of this case is that in June or July 2009, it was decided from a commercial point of view that the Oxygen business had to be disposed of. Precisely how that was achieved was the purpose of obtaining the services of Deutsche Bank, PwC, and De Vrij. Of course, professional men will be expected to give advice to their clients from time to time, including advice about how and whether to proceed with the business. That does not alter the fundamental commercial reality of what being decided by the client. My criticism of this, and of my learned friend's case, is that this doesn't proceed to analyse the nature of the expenditure by reference to what we actually got for it, namely services of a type that we procure regularly. It identifies it by saying that from the point in time at which you decide strategically that you would like to dispose of an asset, automatically everything which comes after that point in time constitutes capital expenditure.
But is that quite a fair way of putting it, would like to dispose? Had they not actually taken a decision in principle to dispose?
They had taken a decision in principle. I think, my lord, that even if they'd taken a decision in principle to dispose of it, I'm not sure it would make any difference, my lord.
Well, that's why I'm asking you. Actually.
Yeah.
But
I'm not sure it would make any difference, my lord, because it takes two to tango. They needed to have a transaction that they could actually do.
But I think your point is a broader point, that it doesn't matter whether they had or not, or how strategic or how definite the decision was. This is legal services, this is financial advice. We get that kind of advice all the time, we pay for it, it's a revenue expense, and it doesn't matter basically what it's directed to.
Precisely, my lady. This wasn't advice on the particular terms of an SPA.
It was or wasn't.
It wasn't.
Well, some of it was.
Some of it may have been on different
Seen
grounds.
the findings.
But the
Brown's advice was precisely about yes.
Yeah. But the findings of fact in relation to Deutsche Bank and PwC are that it wasn't that, my lady. The findings of fact in relation to Deutsche Bank and PwC.
Is that right? It was the vendor due diligence report for potential purchases. It was the running of the data room for that due diligence process to take place.
My lady, the vendor due diligence report is a case in point. The findings of fact that were made by the FTT in relation to that served a number of different functions. Part of it may have been directed towards the sale of it, but part of it was to enable the company itself to understand its own asset.
Data room.
The data room, I accept, is different.
Well, but just trying to distinguish in your primary case, which is that it doesn't matter, it's all legal services advice, up until the moment it switches from expenses of management into implementation and therefore comes out of the code altogether, you say it is all revenue. But now, are you now looking at your secondary case, which is that if that's not right, and if you do have to pin it on whether there was a particular transaction or not, then you still are on the right side of that line, is that?
Yes, my lady, because the point that's... The reason I identified those principles in relation to the capital revenue cases that were decided in the context of trading businesses are that those principles are helpful, but they don't determine this case.
Yes.
There's nothing in it which is in any way determinative of what the outcome is in this case, but what it requires you to do is to look at the nature of the business and the nature of the expenditure. And in my submission, even on an application of all of that, those authorities that came to date, once you understand the way in which coal's business operated and what it was, these were exactly the type of services that we procured all of the time. Now, it may have had some bearing upon a capital transaction, but there isn't a wholly and exclusively provision that's put in place there.
Where are the findings that say we were always spending money on looking at Oxio and looking at how to get more out of our investment? Where are those findings?
Well, those findings aren't necessarily in relation to Oxio, I accept that, my lady. But there are findings that Mr. McCourt's evidence, which I took you to at the outset, was that we did procure advice from external capacities and circumstances where we didn't have the bandwidth, was the word.
That's about your holdings.
Yes, why not?
You've got to drill down a bit here. I mean, the case here is that in June 2009, a pretty firm decision in principle, not binding, was taken to dispose of Oxio or its businesses. And then professionals were engaged to provide assistance and services towards that end. Now, I just don't think, like my lady has observed, there are findings as to how often that occurred so far as coal was concerned. I mean, clearly coal, if it was an active intermediate holding company, was constantly, as I said before, reviewing its holdings, taking decisions in relation to the businesses of those holdings and so on. But we're talking here about something rather more specific. We're talking here about a decision having been taken to dispose of one of its capital assets and practical steps being taken to achieve that end. And the question is, are those expenses capital in nature? And I'm not sure, frankly, that it matters how often this was done. But having said that, there doesn't seem to be any evidence, any finding, as to how often it was done.
And specifically, how often it was done in relation to either an asset you wish to get a profit on, or how often it was done in relation to a loss-making asset which you had decided to sell.
My Lord, I absolutely accept there's no finding in relation to that point of it, but there is the finding at paragraph 423. Mr. McCord's evidence indicated that much of the sort of advisory work that is an issue in the present case could be, and often was, provided by the group functions, and that Centrica would buy an assistance of advisors like Deutsche Bank for various reasons, but including their ability to do the heavy lifting where there was insufficient house capacity. So it's finding that they were doing this in-house, but they also...
Well, I mean, what is being said here, I think, is how often this sort of advice was provided in-house and how often it was provided by external advisors. Isn't that the point that this is directed?
It is, Madam, but it is...
Doesn't it say how often?
This wasn't a one-off occasion.
Oh, no, I'm sure it wasn't. I mean, that wouldn't be surprising at all, I agree.
And indeed, there was evidence, and there's findings about, you'll have seen in the context of the discussion about the contingency fee.
Oh, yes, well, I've seen that.
Yeah.
Okay. 43.
You better... No.
Thank you very much, Mr. Rivet. You've used up 10 minutes of your reply time, but so if you plan to have 20 minutes available to you.
Thank you, my Lord.
Mr. York.
Can I just set myself up before I've asked? Good afternoon. You won't be surprised to hear me say that the revenue regard this as a much simpler case than the taxpayer does. Our case is, I think, as my Lord Richards indicated, that this is simply a straightforward situation in which a decision was taken to sell a capital asset. Professionals were engaged for that purpose in order to assist in selling the asset. An expenditure was incurred on those services. And those are, certainly in the context of a trading company, would always be capital expenses. The question is, in this appeal, whether there is any difference in the context of this relatively new legislation, although in fact it's about 20 years old, whether it makes any difference that Call was an investment company. And we say it doesn't make any difference because the provision which was introduced in 2004 does not make any distinction between investment companies and trading companies. It is exactly, as you will have seen, exactly the same provision which has been in force in relation to trading companies for many years. And we say exactly the same principles have to be applied in determining whether expenditure is of a capital nature or of a revenue nature in relation to an investment company as it would be in relation to a trading company. So, to put this another way, if Call had been a trading company which had a number of businesses and decided to sell one of those businesses and did exactly what it did in this case, we would submit the answer would clearly be the expenditure which it incurred with the bank, PwC, and the lawyers would have been capital expenditure. There would be no case for saying that was revenue expenditure. Should that make a difference that Call is an investment company, and we say the purpose of the legislation that was introduced in 2004 was to bring investment companies into line with trading companies in relation to this divide between capital and revenue expenditure. I was going to deal with Cole's case on construction, such as it is first. As I understand it, Cole say, for some reason, which is difficult to actually put into words, this legislation, this provision has to be given a different construction from Section 53 and a more limited construction. And we say that's not correct for the following reasons. First of all, it is impossible to come to that conclusion on the words used by Parliament. They are simply the identical words which introduce a well-known concept of expenditure of a capital nature. If Parliament had intended to do something different, then clearly it would have to have used different words. Secondly, it is directly contrary to the explanation of the provision given to Parliament on the basis of which it passed the provision. And that I'm referring there to the explanatory notes, which I'll come back to.
And the explanatory notes in question, these were made available to Parliament prior to enactment, is that right?
Yes, there are two lots of explanatory notes relevant. One of the explanatory notes to the corporation tax bill. So they were the explanatory notes to the bill as it was going through Parliament.
Yes.
But there's also, that's a 2009, but there are also the explanatory notes to the 2004 Finance Bill, which was the time when the provision was originally introduced. So it was introduced in 2004 in the Finance Act by an amendment to what was then ICTA, Income and Corporation Taxes Act, and it was then consolidated or rewritten into the Corporation Tax Act,
Yes.
2009. So we now have two specific acts in relation to corporation tax in the UK, Corporation Tax 2009 and 2010, and so there's a very great amount of legislation now about corporation tax. So that's the second point. The third point is that it is inconsistent and illogical, even in its own terms, and also, I would submit, wholly unclear in the way that it is put in my learned friend's case. And fourthly, it's based on an unsupportable, we would say, analysis of Mr. Justice Patton's judgment in Camas and the conclusions which it is said were allegedly drawn from it at the time. I'm referring there to the point that it's been suggested that Mr. Justice Patton's judgment cast doubt on the assumption made by the House of Lords in Sun Life that the costs of acquisition of an investment were not expenses of management. If you remember, some of the House of Lords.
Well, it was
in
a
Sun Life.
concession that they were.
It was a concept. Well, it was agreed, I think, by both. It was common ground in that case, and the House of Lords accepted it. And indeed, I would submit they based their decision on that.
But they seem to have accepted it with some reluctance, but they did accept it.
A couple of, perhaps two of their lordships expressed some doubt about it. But the fact remains that the reasoning of, I think, all of the majority is based on the initial proposition that the costs of acquisition are not expenses of management. Because they go on to say, well, if that's the case, then costs that are that cannot be divided from it, such as stamp duty, must also be not expenses of management. So in my submission, in fact, it is a core part of the reasoning of the House of Lords, although as I quite accept a couple of the members expressed some doubt about it. But in any case, my point is that there's nothing which casts any doubt on that in Mr. Justice Patton's judgment in Camas, and I'll just take you to that briefly. You've already been to it, but In fact, you will see when you read it that both sides argued the case on the basis that Sun Life was correct. And Mr. Justice Patton decided the case on the basis that Sun Life was correct. And no one expressed any doubt about it. In any event, in my submission, it is elementary that a statutory provision is not limited in its effect to the precise mischief which might have prompted it, unless, of course, it is expressly so limited. So even if it was the case that that was one of the reasons why Parliament legislated in 2004, the fact remains that Parliament legislated by providing for an exclusion for expenditure of a capital nature. And one cannot say, one cannot limit that simply by what the precise mischief was that was perceived at the time.
Yeah.
And finally, I don't know how far my learned friend pushes this argument, but as far as this purports to be an argument from absurdity, which is raised in the case, there is the appellant's case, we would submit that is simply a direct attack on the policy choice made by Parliament. So if I can perhaps just develop those points just a little. I'm not sure I need to develop the first point, because the first point was the wording of the legislation, and the court has seen section 12193A. You haven't been shown in this hearing section 53, but I'm hoping that you will appreciate that it is worded identically to that provision. I can take you to it if I
want to
want.
ask you about that. I mean, given that one starts off questions of statutory interpretation by focusing on the words used, and given that it's a big point that the words used are identical, it was slightly surprising not to find the section in the bundle. But
It is in the bundle. It is in the bundle.
It is in the bundle.
It's slightly confusingly set out. I think that's the problem. It's on page 1099.
Yeah, cool.
I had difficulty finding it as well. Because what?
53(1), yes, I see what you mean.
This hasn't been set out by a chronological. You might assume that you would just start with the earliest section of the Corporation Tax Act and then go right through, but that's not what's happened in this bundle. There are separate sections that have been carved out for some reason. But anyway, it is there.
It was certainly been quoted, but it's quite helpful to see it in its form.
Yes. So it's on 1099.
Yes.
It's not absolutely identical.
No, okay. I quite accept that for a few words. But the crucial part, no deduction is allowed for items of a capital nature, is sufficiently similar. Apply submission. And it's the capital nature that apply submission is important.
But what is the item here?
In section 53.
No, in this case, what is the item?
Well, that is a point I was going to come on to, because I think that is one of the points my learned friend makes, that things changed. So if you look at it from the point of, can I just answer that? If you look at it from the point of view of Centrica, what they were seeking to dispose of was the Oxial business. They looked at it commercially as a disposal of the business. They weren't concerned about the mechanics of it, how it was actually sold. In other words, whether there was a corporate sale or an asset sale or whatever. There are some findings of fact by the FTT that's how Centrica looked at it. They wanted to get rid of the business. Now the business was in a company which was owned by Call, and there were 4 subsidiaries, as my learned friend said.
So which of the, I'm awfully sorry, which of your
It's not one.
going through your various points.
I'm sorry, I was just asking, I was just answering Lady Rose's
Well,
question.
my lady Rose asked about what was the item, I think.
In
And
section
the item
53.
surely are the fees charged by Deutsche Bank and so on.
Well, that's what I was asking.
Sorry, the item in the piece.
In 53, in calculating the profits of a trade, no deduction is allowed for items of a capital.
Oh, I see. Yes,
My lady asked what is the item here. Presumably it's the professional fees.
it would be. If
It's items of expenditure.
you're applying that to this case, yes. Yeah, sorry, Malone. Yeah, that's right. Yes. The items would be the equivalent of the expenses.
Well, the
In-
items here are the expenses
The expenses of
charged, the
1219.
claim is made.
Yeah. I'm sorry. I'm sorry, I thought you were asking a different question, which was what was the capital asset, which is a slightly more difficult question. So that the wording, in my submission, the wording is enough. You don't really need to go any further because the wording is quite plain. They've used a well-known concept. But of course, the background to this is also important, as it has been accepted this morning. The background to this was the decision in Camas, which was that the revenue were arguing that there was an implicit or implied capital bar within the wording expenses of management. So the expenses of management did not include capital, and that was rejected by the courts in Camas. And it was that's the context in which this legislation was enacted, as we shall see.
I think you would accept that not all legal advice or financial advice obtained by a company is an item of a capital nature. There's some which would be of a revenue.
Of course, yes. Much of it.
Right. So the what everyone's actually doing on a day-to-day basis is not different. The advice is the same. So what is it that turns legal advice into advice which is an item of a capital nature if it might not in other circumstances?
Well, it depends what the advice is on. If the advice,
Right. So you say it depends what the advice is on.
yes, we'll see that it's what the expenditure is on or for is the question as regards capital. That's what the cases say. For instance, Lawson and Johnson Matthew, my learned friend, showed you the passage. I mean, that's the central authority, one of the central authorities on this. So you've got to look at what you can't just say legal advice is capital or revenue, or you can't just say advice is capital or revenue. You've got to look at what you're looking at is what the expenditure is incurred on, which takes you to look at what the advice is that you're incurring the expenditure on.
Say that bit again.
You're looking at what the expenditure is incurred on, and that takes you, in the context of legal advice, to look at what the legal advice is that you're incurring expenditure on. So you cannot make an a priori assertion or assumption that for instance, advice is going to be revenue or legal advice is going to be capital or whatever. It's capable of being both, depending on what the advice is. So if you're, for instance, seeking advice on, if you're being sued by a supplier in your trade and you were seeking advice on the contract that you had with your supplier, that would be almost certainly revenue. That would be revenue. But if you're seeking advice on, for instance, seeking planning permission over over land that you own, that would be capital. That's ECC Quarries case, which is referred to in the Court of Appeal decision.
Yes, well, that's why I was asking what is the item, because actually the advice takes the colour of the item
Transaction.
of the transaction it relates to. That's your...
Yes,
Then you set that transaction against the background of the business of the company. Because if you're a property development company, then obtaining planning permission would be a revenue expense, I imagine. If your business is acquiring, developing, and selling
Yes.
property.
exactly. Yes, I was assuming that it was a capital asset that would be.
understand.
Yeah, I understand. Yes, you're absolutely right. And that's the point that is made in the authorities a number of times. I'll take you to one example about looking at the nature of the business. Because if you're in the business of buying and selling these items, then it would be revenue. If you're in the business of something else, but you have these items as capital, then it would be capital.
And is that how it works with trading businesses?
That's how it was a trading business, yes. Well, these cases are all about trading businesses.
I think you made it clear in your written case, paragraph 32, that the day-to-day expenses of an investment company, that is, day-to-day staff costs, are never items of a capital nature.
I wouldn't say they were never items, but in general they're not, because they are day to day. It is possible you could have staff seconded onto a particular capital project, for instance, disposing of an asset, and then the staff costs could be capitalised and could be capital in those circumstances. But that's probably unusual.
And here, the battle lines have been drawn in a way that internal involvement in these transactions hasn't been asserted by the revenue to be a capital expense.
No, not in this particular case. I mean, there may be reasons for that.
And I'm just talking about this particular case.
Yes.
We can put the internal staff to one side.
Yes, exactly. But I wouldn't be taken to say in principle that can be the case. Indeed, the Wharves case, which I might take you to, Lord Hoffman makes the point that electricians could be capital or could be revenue, depending on
Yes.
circumstances.
Yes.
Yeah. I wonder. That might be.
Would that be convenient?
It would be a lot, yes.
Please take the shorter journalist. Thank you very much.
Okay.
Yes.